Who is ready for some nightmare fuel for some gun controllers? Welcome back, brothers and sisters. I am Braden, and this is Langley Outdoors Academy, the place where we not only talk about what's going on in the gun world, but also how we're going to fix it together. And this is a celebratory video because the ball has begun rolling. We have finally found out if magazines, those extended, feisty ones, the large capacities, the LCMs, are unconstitutional or not. And you guys know the answer, and this is going to be fantastic. Everything will be linked in the description box below, and I can't wait to hear what you guys think in the comments. And please, send this one out, because as I mentioned a second ago, we are rolling the ball towards victory. It's going to take time, but we are going to get there. Right now, let's live in it, because like I said, this is that nightmare fuel for gun controllers. Bruin has struck again. And of course, make sure you like the video, subscribe to the channel, and turn the notification bell on. All right, so it's Friday, and we are going to send off in an amazing fashion. Let's get into what we're talking about here. This is the Duncan versus Bonta case. This is the whole shenanigans around large capacity magazines and the ban of said magazines, LCMs, as they like to say on the gun controlling side of constitutionality. Well, turns out they were wrong. Let's keep going. We begin at the end. California's ban and mandatory dispossession of firearm magazines holding more than 10 rounds, as amended by Proposition 63, was preliminarily enjoined in 2017. That decision was affirmed on appeal. In 2019, summary judgment was granted in favor of plaintiffs and in its entirety was judged to be unconstitutional. Now, of course, when it was judged as unconstitutional, the Bruin decision came out. Well, when the Bruin decision came out, they had to go through the whole shenanigan again. I don't know why, but shenanigans seems to be fitting for this because it's out of California. But it's so fitting that California is really leading the charge in getting the most extreme, egregious gun control measures nationwide struck down. How's that saying go? As goes California, goes the nation? Just saying. Thanks, Gav. One government solution to a few madmen with guns is a law that makes into criminally responsible law-abiding people wanting larger magazines simply to protect themselves. The history and tradition of the Second Amendment clearly supports state laws against the use or misuse of firearms with unlawful intent, but not the disarmament of the law-abiding citizen. That kind of solution is an infringement on the constitutional right of citizens to keep and bear arms. The adoption of the Second Amendment was a freedom calculus decided long ago by our first citizens who cherished individual freedom with its risks more than its subservient security of a British ruler or the smothering safety of domestic lawmakers. Can I get that on a t-shirt? That is excellently written, and this is Benitez writing this, by the way. The freedom they fought for was worth fighting for then, and that freedom is entitled to be preserved still. The Attorney General respectfully requests a stay of any judgment in plaintiff's favor for a sufficient period to seek a stay from the Court of Appeals. Now, that's what's going to happen. The next steps I'm going to get into in a second, but this is not the fight is not over, but it has begun. The process has begun to go to the higher levels. They have to abide by the Bruin decision. If they don't, you get more appeals going higher and higher and higher. This is a matter of time. Let's continue the last thing, because here is the actual order, which I know you guys are going to love. It is hereby ordered that Defendant Attorney General Rob Bonta and his officers, agents, servants, employees, and attorneys, and those persons in active concert or participation with him, and those duly sworn state peace officers and federal law enforcement officers who gain knowledge of this injunction order or know of the existence of this injunction order are enjoined from enforcing California Penal Code 32310, which means they can't do it. They just got stopped. Hard stop. Can't enforce this anymore. It's unconstitutional. Freedom was worth defending then. It is worth preserving now. Amazing. Because again, zoom out. Think about every other state that has magazine bans or LCMs or large capacity magazines, AR bans, all these extreme things. Think about Measure 114, which is currently going through the court system in Oregon. All of these things are predicated on the idea that they can infringe rights because of a scary safety that they want to apply, which is not in line with the Bruin decision. Bruin is on the wrecking ball again. I'm telling you, this is a big deal. Now, let's continue. Defendant Rob Bonta shall provide, by personal service or otherwise, actual notice of this order to all law enforcement personnel who are responsible for implementing or enforcing the enjoined statute. This injunction is stayed for 10 days from the date of this order. It is so ordered. September 22nd, 2023. Honorable, very honorable, Roger T. Benitez, United States District Judge out of California. Now, this is the same guy who compared an AR ban or an AR to a Swiss Army knife, made Gavin Newsom go apoplectic. But you have to understand what this means. Does it mean that it's an absolute victory at the end? And is there an injunction for 10 days? Yeah, there's an injunction for 10 days. But the entire thing has been enjoined. At the end of 10 days, the state of California, Rob Bonta and Gavin Newsom, they're going to push it further up in the next court system. And that's why it's so important. Because as it goes higher and higher and higher in the system, you start to look at exact examples in other states, and you can start to see the entire thing crumbling. If you look at the shall issue versus may issue, which actually instigated Bruin would not have been possible if they had not infringed upon the idea that you could have a concealed carry and have a license with that concealed carry issued by the state. Now, licenses, in my opinion, shouldn't be necessary. That's why I like constitutional carry. But that's the point. Their perspective was you have to have a license, and by the way, we're not going to give you that license based unless you prove you need it. That's not constitutional. That's the entire point. When you look at AR bans, when you look at mag bans, it's all much ado about nothing because they wanted a victory, and they're about to get struck down too. If you look at every single thing that they've done on the gun controlling side, it's getting struck down left and right. It is a wrecking ball out here, which is why we are covering all of these things every day in, day out, twice a day. This is a really, really big deal. And let me know what you guys think in the comments field, and I will see you on the next one. I'm Braden. See you later.